Well, my name is Sonam Narayan, and I'm currently pursuing BA LLB from University of Petroleum and Energy Studies. I'm in my fourth year, and I'm interning under the LEXIS and Company. And today in this video, I will be talking about the main features of the Surrogacy Act. So the Surrogacy Act prohibits commercial surrogacy, but allows altruistic surrogacy. Altruistic surrogacy involves no monetary compensation to the surrogate mother other than the medical expenses and insurance coverage during the pregnancy. Commercial surrogacy includes surrogacy for its related procedures undertaken for a monetary benefit or reward exceeding the basic medical expenses and insurance coverage. Now, purposes for which surrogacy is permitted. Surrogacy is permitted when it is for intending couples who suffer from proven infertility, altruistic. Thirdly, not for commercial purposes, and fourth, not for producing children for sale, prostitution, or other forms of exploitation. uh, it for it also says that for that the purpose for surrogacy is permitted can be for any condition or disease specified through regulation. Now, what is the eligibility criteria for intending couple? So the intending couple should have a certificate of essentiality and a certificate of eligibility, which shall be issued by the appropriate authority. Now, a certificate of essentiality will be issued upon fulfillment of the following conditions. First, a certificate of proven infertility of one or both members of the intending couple from a district medical board. Second, an order of an order of parentage and custody of the surrogate child passed by a magistrate order. And thirdly, insurance coverage for a period of 16 months covering postpartum delivery complications for the surrogate. Now, the certificate of eligibility to the intending couple is issued upon fulfillment of the following conditions. First, the couple being Indian citizen and married for at least 5 years. Second, the age shall be between 23 to 50 years old in case of wife, and 26 to 55 years old in case of husband. So the age eligibility is between 23 to 50 years old for wife and 26 to 55 years old in case of husband. The other condition is that they do not have any surviving child, biological, adopted, or surrogate. This would not include a child who is mentally or physically challenged or suffers from life-threatening disorder or fatal illness. Now, another condition is that other conditions that may be specified by regulations. Now, what is the eligibility criteria for surrogate mother? To obtain a certificate of eligibility from the appropriate authority, the surrogate mother has to be first, a close relative of the intending couple; second, a married woman having a child of her own; third, she should be between 25 to 35 years old; fourth, a surrogate only once in her lifetime; and fifth, possess a certificate of medical and psychological fitness for surrogacy. Further, the surrogate mother cannot provide her own gametes for surrogacy. Now, what is the appropriate authority? Now, the central and state governments shall appoint one or more appropriate authorities within within the 90 days of the bill becoming an act. Now, the function of that appropriate authority includes granting, suspending, or cancelling registration of surrogacy clinics, enforcing standards for surrogacy clinics, investigating and taking action against breach of the provisions of the bill, and fourth, recommend modifications to the rules and regulations. Now, how can we register for these surrogacy clinics? Now, surrogacy clinics cannot undertake surrogacy related procedures unless they are registered by the appropriate authority. Clinics must apply for registration within a period of 60 days from the date of appointment, but from the date of appointment of the appropriate authority. Now there shall be national and state surrogacy boards. Now the central and the state governments shall constitute the NSB, known as National Surrogacy Board, and the SSB, known as State Surrogacy Boards, respectively. What will be the functions of the NSB? It will first to advise the central government on policy matters relating to surrogacy. Second, it shall lay down the code of conduct of surrogacy clinic. Thirdly, it shall supervise the functions of the SSBs. Now let's talk about the parentage and abortion of surrogate child. A child born out of a surrogacy procedure will be deemed to be the biological child of the intending couple. Now, an abortion of the surrogate child requires the written consent of the surrogate mother and the authorization of the appropriate authority. Now, this authorization must be compliant with the Medical Termination of Pregnancy Act 1971. Further, the surrogate mother will have an option to withdraw from surrogacy before the embryo is implanted in her womb. Now, what are the offenses and penalties? So, the offenses are offenses under the Act includes the undertaking or advertising commercial surrogacy, exploiting the surrogate mother, abandoning, exploiting, or disowning a surrogate child, and fourth, selling or importing human embryo or gametes for surrogacy. Now, the penalty for such offenses is imprisonment up to 10 years and a fine up to 10 lakh rupees. Now, the bill specifies a range of offenses and penalties for other contraventions of the provisions of the Act. Now, the information for this video were taken from the BRS Legislative Research. Thank you very much.